So what is bail reform?
Well, it's funny that you asked that because it's not really bail reform. It's criminal justice reform. And the reason for that is that 2 years ago, the citizens of the state of New Jersey voted for a constitutional amendment that repealed the constitutional right to bail in this state. There's no longer a constitutional right to bail. It's a computer program that does what's called a public safety assessment. They consider a series of 9 factors. However, that decision isn't made directly or only by the computer. The prosecutor, the state, has the ability to request a detention hearing. And at that detention hearing, they have the burden of convincing the state that somebody is dangerous based on the nature of the crime or whatever other factors there are, so that they may be detained without bail. On the other hand, if they don't request a detention hearing, the state has 2 days in which a study is made, a social study is made, and the information is fed into a computer, and the computer will give a public safety assessment. And if the public safety assessment says that somebody's not dangerous, a judge will, using suggestions from the computer, design a program that will allow pretrial release. It's one of the reasons for the reform. It was felt that there were a lot of people who didn't have the money to post bail, who were kept in jail, who really didn't need to be. There was no scientific approach to whether they would appear or not. So this public safety assessment does 2 things. It determines that if they're not at risk, there will be ways to assure that they come to court that don't include their having to put money up. And that's a really admirable objective. Whether it works or not remains to be seen, but it's an admirable objective. Although the law is written so that the state has to provide discovery and call witnesses if they're going to have one of these hearings, there's been a decision or an attempt statewide to base these decisions on hearsay and proffers. So some defense attorneys are issuing subpoenas. There's a lot of confusion and flux about this issue. You'll have to check back on a day-by-day basis to find out how it's working out. Well, one thing a lawyer can do is help get together information that might help us challenge the information that went into the computer system, or give some supplement to a judge who has, and the judge will use that for some input on the release considerations.